afternoon, ladies and gentlemen. Welcome to BW Legal World's Salary Solution segment, where we speak with experts on hot legal topics and latest legal developments, usually on Saturdays. However, we are making a departure from that and holding this session on Thursday this week to make room for Christmas joy over the weekend. So, very Merry Christmas to all of you in advance. Now, back to the topic of the day. We are here to recap some landmark developments in the legal landscape of India, especially from important disciplines of law like international trade, competition, private equity, patents, civil, criminal, and tech laws. To know more and to make this discussion fruitful, we are joined by Ms. Gayatri Roy, partner, Saraf and Partners, Mr. Bharat Chugh, founder, the Chambers of Bharat Chugh, Mr. Manav Nagaraj, partner, Shardul, Amarchand, Mangaldas, and Mr. Parthsarathi, partner, Economic Laws Practice. I'm Ashima, Ohri, managing editor of BW Legal World, who has the honor of moderating this August session. Experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. Let's dive right into the conversation with our panelists. So, panelists, could we have a brief precursor to what landmark developments you would be discussing today and why that's relevant? We'll start with Gayatri. Gayatri, over to you.
Hi, good morning, everyone. I hope it's not too early. Nice to be on the show. Thank you, Ashima, for calling me in. Today, I'm going to deal very briefly with, rather than a landmark event, I'd like to identify it as an event which is maybe going to shape, the landscape of IPR disputes over the next few years, at least. So that's, that relates to the disbanding of the Intellectual Property Appellate Board and a commercial court taking its place. I think that's one very significant development that's happened this year. A second significant development that's happened is that a lot of the amendments to the Copyright Act in 2012 are now being disputed, are subject matter of disputes in courts now, and they're coming closer to judgment. So that's another development which I think needs to be followed and will unravel over the next year or so. The third development is in relation to data protection, less a development in terms of having a law soon, but more a development in terms of how wide-ranging the comments of the Joint Parliamentary Committee are. Thank you.
Thank you, Gayatri. For that, Bharat, coming to you for what you have in store for us.
Oh, thanks, Ashima. Thanks for having me here. I'd like to talk about three of the practice areas that I work on. One is commercial disputes. So I'll be briefly touching upon the new mediation bill and how does it seek to change the mediation ecosystem in the country, how it would make mediation settlements more enforceable, it would give sanctity and recognition to the process, and also briefly a couple of pitfalls with how the law has been designed and how it is in the present shape. Another important practice area for me and for every dispute professional out there is white collar crime and financial crime defense. And I think we've had a very significant judgment of the Supreme Court called the judgment in Tufan Singh's case on the question of who really is a police officer for the purposes of criminal law, which has a huge bearing on how crimes are investigated across the country, not just by the police, by CBI, by special agencies like the ED, the SFIO, and great constitutional implications too for accused persons on what would be the evidentiary value of the statements given to such investigative agencies. And so I'll talk about civil, criminal, and tech law. I mean, I'm certainly biting off more than I can chew, and I'll be touching only the tip of the iceberg. But also on tech law, briefly a discussion on the new intermediary guidelines. I think a very important milestone. And look forward to a great discussion.
Thank you, Parth. Thank you so much for choosing those avenues. And Parth, coming to you for your choice of topic today.
Thanks, Ashima. Thank you for calling me in here, and great to meet all the co-panelists here. So I practice trade law and competition law. That's the area where I advise clients. So I'll be touching both the areas. And in competition, I think the trend which has started is about regulating the tech sector and also some of the emerging areas of economy, including e-commerce. And that trend is likely to continue for some time now. And I will be surely talking about the Amazon order of the CCI and what it means for future filings, which happens before Competition Commission of India. So I'll be talking about the competition implications of this order, not the general wider implications, the dispute between Future and Future Group and Amazon. So that's not my area. I think someone from the litigation side will be able to explain that more, but I'll be touching on the competition issues. On trade, again, the trend largely, which we have seen in the last couple of years, is about more and more isolationist approach, more and more protectionism. And that approach is going to continue despite some large promises of MC12, which didn't happen. But we do see that this trend of protectionism in one or the other way will continue to happen. So protectionism could be for self-sufficiency, manufacturing capacities within your own territory. It could be on the garb of certain larger promises like climate change and all. And in this perspective of the European proposal to come out with a carbon border tax, which has ignited a lot of debate, and it's going to impact Indian exporters a lot. I will be touching upon CBAM. In addition to this, of course, there are many other issues which I think are very relevant: fisheries subsidies, the e-commerce discussions which has happened at WTO, and India having its own e-commerce. Gayatri touched upon the data issue, and there is some issue of data flow, cross-border data flow in the e-commerce discussion. But I do know that there is limitation of time, so I will focus mostly on the carbon border tax, which is proposed by European Union, and how it is going to impact Indian exporters. Thank you.
Thank you, Bharat. Thank you so much. Looking forward to that. And Manav, now over to you.
As some of the other panelists have mentioned, thank you for this initiative, Ashima, and for having all of us here. I think the panelists between all of us cover most areas that are there. So we've spoken about IPR, we've spoken about trade, competition law, commercial disputes, white collar crime. I think what is left is the area of law that I practice in, which is transactional law. I'm a transactional lawyer focusing on venture capital, private equity, M&A. So what I'd like to speak about is some of the trends and challenges and practices in this space in 2021. Pre-COVID, during COVID, hopefully post-COVID. What are some of the challenges been? How have some of the large players been approaching this? What are some of the trends that the industry is seeing? And hopefully, without playing Nostradamus too much, what we'd like to look forward to in 2022, and what we'd like to see, where we'd like to see policy clarity, where we'd like to see some sort of regulatory clarity, and how we'd like the sector, the practitioners, and the trends to evolve.
Great. So we have a 360-degree view almost out here between the panelists. So coming back to Gayatri, you mentioned IP appellate board and copyright amendments. So could we hear more on that?
Yeah. So I'm going to say it in okay, so I'm going to be brief about it, because otherwise we can go on about it endlessly, all right? So I'm just going to try to keep it brief. Now, the thing is that even before 2003, before the appellate board was formed, we did have the system where the High Court had jurisdiction over challenges to intellectual property that, say, the IP offices were dealing with, whether it's the Registrar of Trademarks, the Controller of Patents, the Registrar of Copyrights as well. And so in that sense, the IPAB being disbanded and a commercial court taking its place is not unique. It's not a new thing. We are in a way doing, but we're doing it in a different way to, in my view, firstly, because it's a commercial court. So, the entire, efficiency of the commercial court system is being brought into it in terms of timelines, in terms of case management, etc. So that's one area which I think is significant. But I think the other area which is, equally significant, and I think the Delhi High Court has shown the way because they've set up what is known as the IP division, is how much flexibility the Commercial Courts Act actually gives in order to, decide these disputes quickly and efficiently. And that is what you're going to see, because what you see is that the Delhi High Court has earmarked 6 judges, that are part of the IP division. They're going to look at all of the cases. You've seen a lot of cases being filed, and that's the huge efficiency that's going to come in. And I expect it will get replicated in other courts, and even a district court, falls within the definition of a commercial court. So you're taking away one institutional bias, you're taking away backlog, you're taking away non-functioning of the IPAB and bringing in, the entire network of courts, for IP, from A to Z aspects of IP, right? So that I think is going to make things, go much faster. And IP is becoming a pretty significant commercial asset for companies. So it's a recognition of that. I'd say that. So that's where I think it's really going forward. I think the second area, which is a huge, kind of way forward, is the new patent rules that the Delhi High Court is considering. Now, that is going to streamline and make trial much easier. Instead of going with a whole host of issues to trial, you're able to go in with very specific issues, and that results in efficiencies, which is going to encourage patent disputes and limit costs to an extent. So that is another development that I think in the years to come will be seen as a very significant development that's taking place. Again, the expectation is other courts in India will follow the example that the Delhi High Court is laying down. The third aspect on the 2012 amendments to the Copyright Act, I think we're in 2021, and the litigations may have really started in seriousness maybe last year or so. Right. The first one that we're seeing is with respect to royalties to be paid by radio broadcasters. We have a decision of the Intellectual Property Appellate Court when it was there, and one of the Delhi High Court, which are diametrically opposite to each other. And now the entire issue is before the Delhi High Court. One is before the IP division, and the other is before the Appellate Court. So we have that working out. There have been a lot of judgments from the Madras High Court as well. On the Copyright Act over this year, which relates to various amendments. So we are seeing that the 2012 amendments are likely to get interpreted maybe over the next year or two. I expect it to go all the way up to the Supreme Court. You're also seeing the possibility, consideration, the government considering whether internet platforms, right, music streaming platforms should be given the benefit of statutory licensing. That's yet, we need to see what the government does about that. I think that there are reservations of the music industry because you're going to ultimately make compulsory licensing available to the entire distribution model for music. So that is a concern. So that's where it is. I think the third area is data protection. If you'd like me to go into it in this round, I can, or maybe I can do it in the next round of questions. And as the other panelists speak about it, it's up to you which way.
Sure, Gayatri. I think it would be great that we come back to it when we have spoken to everyone else. Thank you so much for shining light on some of the other aspects. Coming to you, Bharat, mediation has been the order of the day, and much has been spoken on that count. Over to you for more on that.
Sure. And, personally, I must start with the caveat that I'm a very adversarial litigator, and I really enjoy a good fight in the court, with a cross-examination and a trial on merits. So whether as a judge earlier when I started off my career or now, I am personally, not somebody I think who's very good at it or who personally favors it, but it is good for the system. There's no denying the fact. Mediation can, whether pre-litigation or during the litigation, it can provide resolution in matters where conventional adversarial litigation is not really a solution. And in a mediation situation, more often than not, both parties can be winners in terms of cost, in terms of effort, in terms of getting something tangible out of a litigation. So mediation is here to stay, and it is important. The problem with mediation in India has largely been that it's been very ad hoc, and it's suffered from ad hocism. We haven't had a proper dedicated standalone mediation law. We've had some provisions in different statutes, which have been interpreted very, very differently. So there was a need for a dedicated law to mediation, given how important it is. The importance cannot be emphasized enough. People have said that if we do not take any more cases into the system, even then it's going to take 600 years for us to dispose of the ones that we already have. On my day one, when I started off as a 23-year-old judge, I had 150 matters on my cause list on day one. And it's no surprise that you can't do effective proceedings in those. So in that context, in that background, it's an important law. I basically look at the law in terms of the good, bad, and the ugly. What the law does, which is very good, is it creates an ecosystem. It provides for trained mediators. It provides for a council which would ensure quality of mediations, quality of mediators. One more thing that is very, very important is that it gives the status of a decree to a mediation settlement. Earlier, if you get into a mediation settlement, if one party backs out, which is often the case, or doesn't comply, you'll have to go to the court, seek a specific performance, take that agreement, get it enforced through the court, get it turned into a decree, and then enforce it and realize the fruits of what you have in your hands. And as is often said, The troubles of a litigant begin when they get a decree, because executing is a different ball game altogether for you to realize the fruits of the paper in your hands. So this law or the bill really helps there, where it is easier to enforce those settlements. It is executable as a decree. It's a lot of sanctity. Go to a court, get assets attached of the defaulting party, move forward. So that's very, very good. What is slightly problematic is, and we have to try and be objective about it, is the fact, for instance, that now going to mediation before you file a commercial suit is mandatory. You cannot really institute a suit in a court of law before going through the rigmarole of a mediation, which is pre-litigation mediation. Now, we had something like this in the Commercial Courts Act, 12A of the Commercial Courts Act, but it had a very clear exception. If you're seeking any urgent interim relief, you can always go to the court and sort of bypass the pre-litigation mediation requirement. Now, the way the present bill is structured, it doesn't give you that clear exception. Although it does say in extraordinary situations, you can go to the litigation directly, because in many cases, you would want the indulgence of the court very, very quick, and you don't want to be spending those 3 months in mediation. It says in extraordinary situations, you can bypass, but then again, it's extremely vague on what can be construed as extraordinary and would lead to a lot of litigation on what those situations are. And I personally think that you cannot really incentivize mediation by making it compulsory. You can incentivize it, for instance, with how UK has done it, where if a party unreasonably or unjustifiably refuses to engage in mediation, and the case goes through a trial, and then there is an order at the end of it, the party who did not mediate should be burdened with costs for not having engaged in mediation in a sensible manner, instead of making it mandatory before you come to the court, which has serious access to justice implications, right? And which, in my humble opinion, also renders the provision itself constitutionally vulnerable. So a different approach is needed. You can't just have a stick-only policy that you can't come to the court. You have to go to mediation, especially when so many people do try mediation sensibly before they come to the court, and only if it hasn't worked out that they are finally compelled to come to court. Nobody loves to come to court with how the system sort of worked over the last few years. So in those cases, again, 3 months are spent, or a lot of time is spent in trying to resolve something which could have gone to the court directly. I mean, I can spend a lot of time just discussing that, but again, I personally think there's good, there's bad. Another problem that I find with the new bill, and I hope that's creased out when we finally debate it, is that again, a lot of exceptions to enforceability of mediation settlements. It says that if there are allegations of fraud, you cannot mediate, or that mediation settlement would not be enforceable. Now, we do understand that in every commercial dispute or every second commercial dispute, one party would be alleging fraud. Now, just because somebody said that magic word doesn't mean that the dispute should become incapable of mediation. And we've seen the defense of fraud being misused a great deal to sort of throw a spanner in the works in arbitration proceedings, where there were some decisions which said fraud is inarbitrable or a serious fraud is inarbitrable. Now we are stepping into the same sort of problems by having this, and so definitely something. And the last thing that I'll close with in the affirmative is the fact that the bill does talk about a mediation council to uphold standards in mediation, quality in mediation, to ensure that we have good trained mediators and infrastructure. But on the mediation council, to the best of my knowledge, it doesn't envisage lawyers or mediators being there on the mediation council. Now imagine having a bar council without lawyers being there to regulate the affairs. I mean, nobody knows the ecosystem better than a mediator herself or a lawyer himself. So these are some of the problems, and but all in all, very positive, a great step forward, aligns us to a lot of international obligations also that we have in terms of the Singapore Mediation Convention, may make India a more attractive jurisdiction to mediate. But yes, there are a few things that we need to work on. Maybe towards the other parts of the discussion, I can quickly weigh in on the other aspects of financial crime and what's new there, or the intermediary guidelines should time permit, and after everyone's sort of weighed in.
Thank you. Bharat, just a quick question on your statement, taking from your statement that you're a judge and you like your arguments. You think judges will make for a good mediator? And a more serious question coming later.
I refuse to answer that question on the grounds that the answer may incriminate me. But so being a judge, the training of a judge, you're conditioned or hardwired to think more objectively, to take a step back, to be more dispassionate, to be more empathetic, be clinically, detached. You're not in the dispute, you're not emotional, you're not in the moment. At the same time, you're responsive and sensitive. And all of these qualities also go on to make a good mediator. But again, there are a lot of differences in terms of skill sets also. A judge is taught to be an adjudicator. He's taught to appreciate evidence, sift the chaff from the grain, find out what the judge's conception of truth is, right? Every trial is a voyage of discovery, with truth being the ultimate quest. So that's a fact-finding mission. A mediator is not necessarily somebody who's sort of fact-finding. He's there for a resolution. We learn this example at judicial academies across the country. That, for example, there are two people fighting over an orange. Right, a judge is going to say, "Oh, let me inquire on who the orange belongs to, who has the title, who bought it. Let me hear witnesses, take evidence, and then decide who has ownership and title over that piece of fruit." But a mediator is going to ask those people, "What do you want with this? What do you want to do with this orange?" One person may say, "I want to make a face pack or something." The other may want to say, "I want to take the peel and have the juice." And then he can say, "Okay, you take that part of the orange, you take that part of the orange," and it's a win-win situation for everyone. Everyone goes back home happy, and there are no losers at the end of the day. Now, a judge may, if strictly speaking, would not look at it this way. The judge is supposed to say, "You're right, you're wrong," and that's what the evidence says. A mediator, of course, some judges do it brilliantly. They are able to, switch those hats very effectively and don the mantle of a mediator do really well. It takes training, and with adequate training, why not?
Absolutely great reply there, Bharat. Thank you so much for that example of orange. I'll remember it forever. Now, coming to you, Parth, on competition and international trade, trade wars and supply chain disruptions, all of them have been buzzwords through the pandemic. What's other than this happening, you mentioned fishery subsidies and all of those things, but also climate change and carbon tax emissions. So carbon border tax. So looking forward to learning more on that.
Sure. So let me first address the competition bit, which is Amazon order, and maybe time permitting, or in the next round, I'll pick up the trends in trade and particularly the carbon border tax. So on Amazon, of course, we have perhaps all gone through the order. The outcome, what has happened before the CCI, of course, is part self-inflicted by Amazon. I mean, basis what has been written in the order, and if those facts are true, it is true that the acquirer, in this case, Amazon, did not perhaps present the full picture before the CCI, and maybe perhaps even misrepresented in terms of what the real objective of the investment was. But the way order has come out and the way we understand the scheme of the act, it raises several questions. One of the questions, of course, is that what's the role of a target? Now, if you look at the Competition Act, the filing requirement in case of acquisition, when we are acquiring shares or voting rights or control, it's on the acquirer. So before the commission, the person who stands is acquirer. But be that as it may, acquirer cannot file the notification because the questions in a notification are such that you will have to necessarily engage with the target, and you will have target specific information as well. Otherwise, you can't really fill the form, whether it is Form 1 or Form 2. It's a collaborative effort. And my own experience is that in most investment agreements, or the sort of whatever you give it to, typically a target has a say on the filing which you do before the CCI. So you can't just prepare something and go and file as an acquirer because the CCI. Typically, parties agree that every communication which goes to the CCI, the other party will also have a say on that. Only if other party approves, it goes to the CCI. Now, but before CCI, it's only acquirer. So acquirer has to file the notification. Acquirer has to give a sort of declaration that everything what is being said is true to the best of the information. All of that. A target is not there. Now, if you look at the Amazon case, right, I mean, whatever has been presented before the CCI, although I'm not party to what the transaction has happened, I'm not the lawyers, but it's likely that the target knew what is being presented before the CCI. Like I said, it's typical of any investment agreement. And the same target today has gone to the CCI saying that this approval should be withdrawn because the acquirer misrepresented. Now, nobody has stopped the target at the time when original filing was done to say to the CCI that, well, the facts are not correct. I mean, there is no stoppage in the scheme of the act that a target cannot go. And that raises a wider question that should it be only the role of the acquirer? If you look at the order, I see Amazon did take an argument that future has not come out in clean hands. To an extent, that argument was self-incriminating, but without going into that, and that argument has not been addressed by the CCI. So this is an issue which needs to be debated, and of course, this order is going to be heavily appealed and litigated, and mainly to reform here. That's point number one. Point number two is, of course, role of regulator itself, and that somewhere is connected with how you file forms. At some level, one will argue, or one can see it, that CCI itself has abdicated its own function. Now, CCI is supposed to inquire in double quotes, inquire into a combination. And what is the meaning of inquiry into? Does inquiry mean that I say something and you take it on the face of it? Because let's understand, every relevant document was on record before the CCI, including the shareholders agreement, which is the issue before CCI, through which Amazon had strategic interest over future retail. That document was also with the CCI. Now, let me give a hypothetical set of facts, right? There's the same set of document, different parties may have different perspective on that document, right? Facts can be viewed differently. And I can say that I am saying true because that's my perspective of the facts, right? And same set of facts can be viewed very differently by someone else. It's role of the regulator to look at exactly what is the strategic intent or rationale behind behind a transaction, which the only way you can look at a transaction is through transaction documents, right? That's the only legal way, written document which you can look at. You can't then say that, oh, you said this. Of course, any party is going to always present things that, oh, this is minority control, this is non-controlling stake, this is minority investment. But as a regulator, you have a job to do. But if you have not done the job, and then that's a question which also has to be, I think, needs to be discussed. And then it is also related to the how do we, in future cases, how do company file forms? At one level, I think, again, it's not an exaggeration. Some people might say that it's overstretched, but somewhere the message is that, look, whatever the documents you place as annexures or as part of evidence, what you write in the body of the form, is that what I'm going to take? So if you're summarizing what is the deal term, or if you're summarizing what the deal looks at, or how the deal has been structured, despite having given everything in detail, and if your summary is not correct or it's not fulsome, you may land in trouble. So these are some of the things which immediately comes to my mind from Amazon, from very computational perspective, what the implications are. There are, of course, other issues of confidentiality and all of that, but I will stop here. And maybe on your larger issues on what is happening on trade, maybe I'll take it to the next round. Unless you want me to take it right now, I'm happy to do that as well. Thank you.
We'd be happy to do a second round. I think there should be time, so we'll quickly bring in Manav and then come back to you. But so thank you so much for shining light on the Amazon case from the competition perspective, which we rarely come to know usually. So Manav, coming to you, everyone's spoken about some of the aspects, but yours is on deals and trends. A year of investment and exits. What's happening there?
I think Ashima and everyone else, I think if anyone had to summarize 2021, right, they'll say it's the year of the unicorn. There have been, at last count, if I'm not wrong, there were 42 unicorns in India that emerged in 2021. Now that gives a couple of indicators. One is that there is a belief in genuine business models and, in sectors, in the economy, all of that larger, consumption story of India. But from a legal perspective, I think there are two things. One is it shows that any investor who's coming in is going to come in with a view to stay there, be part of governance for a while, improve standards of the company and look to exit. So it shows that there's been a reaffirmation on the fact that there is consistency in policy, that there is an ability to get transactions done during COVID, when physical meetings became challenging, and I'll speak about that in a while as to what some of the challenges were in executing this. That there is certainty, or that there is foreseeability, not certainty, in getting exits. There have also been a year of exits, and we'll come to that in a while. And that overall, that there is a belief on the rule of law, that there is an ability to enforce contracts, that there's an ability for parties, different players in the ecosystem to sit down and objectively and quickly and expeditiously agree on transaction documents, get transactions done, not take and I think all lawyers need to take credit here, that the earlier and I observed that Bharat mentioned that he loves an adversarial position, but hitherto adversarial positions in matters including discussions on indemnities, including discussion on liquidation preferences, all of those have more transaction counsels have been taking more pragmatic views to get transactions done. I think that's been a good trend. It's not been without challenges, because venture capital and private equity, the investors have a little bit of a different mindset, as I'm sure you'll all appreciate, that they're not, even though a lot of people use VC and PE in the same sentence, it's not necessarily that they are synonyms. And that the thought and the approach with which different investors approach a transaction is different. What's happened is, given the speed of fundraising, sometimes we've had to grapple with situations where both early stage investors either continue in companies or commit further capital in subsequent larger rounds of fundraising, which are typically growth capital fundraise. And you have a situation where later stage investors are tending to dip their toes in earlier stage investments. So some of the thinking around that, and what necessarily you need to solve for, cleaning up cap tables, having convertible instruments, deferred compensation, all of that have been a bit of I wouldn't say it's been a bit of a challenge, but these have been some of the areas where transactional counsel have had to focus on. I think it's useful for all transactional lawyers at some point of time to have a working knowledge of Excel, given the way that the transactions have been proliferating in the last year or so. There have been other issues in terms of externalization of structures, where Indian companies with foreign hold subsidiaries look to flip and make themselves foreign hold cos with Indian subsidiaries, and there are certain regulatory and tax challenges around that. There have been acqui-hires where sometimes people look to move the team, move the customers. They don't acquire business as much as an acquisition of talent. And some of the, how do you capture value, how do you protect value, how do you preserve value in a company going forward, these have been some of the innovative norms. I think one of the, I wouldn't call it a challenge, but one of the learnings in the last year, maybe a year and a half as well, is the ability on remote diligences, the ability of transactional lawyers, bankers, accountants, tax advisors, all of them to quickly adapt to a virtual data room. How quickly it's been, how people have been able to engage in the absence of physical meetings. It's not that it's been without challenges. Early stage companies are not that equipped to deal with a quick digitization of documents, uploading them on data rooms, answering questions. But I think that's and I think all lawyers need to take credit for this, how quickly law firms and lawyers have evolved to deal with this. One of the challenges has been in terms of completion of conditions precedent. Sometimes when you have lender consents, when you have contract counterparty consents, on occasions when you have regulator consents, especially in the mid part of the year when most of India was locked down, how do you navigate through getting those consents in a relevant and quick point in time? And the other thing that we had to look at is clauses that earlier did not have negotiation to a large extent as to impact of material adverse effects, materiality thresholds in diligence, force majeure clauses, standstill obligations between signing and closing, especially when you had a contract that was signed, pre-COVID, and then there was a condition precedent thing, longer periods for condition precedent, stamping of share certificates, stamping of lease deeds in the absence of, physical offices, obtaining consents from bankers, filing with regulators. I think some of these have been a bit of a concern, especially when transactions have been, when the players in the transactional ecosystem look to close deals in such a rapid pace as the last year has, proved. And to give credit where it's due, all law firms have been fairly quick to adapt, some more than the others, and manage both investors and companies which are looking to raise funds in a quick point of time, because as much as there is capital chasing company, there's companies chasing capital. So you need to ensure that the transaction closes within the point of time that the parties want, while at the same time navigating some of these practical challenges. So it's been an interesting year. It's been an eventful year. It's been a good time to be a lawyer, to evolve, to adapt, to relearn some practices. We are used to having realms of paper, realms of printouts, looking at data rooms. So moving to the virtual space, working with teams across locations, across jurisdictions. I think it's been interesting. I wouldn't say per se that it's been challenging. In part, it's been challenging, but it's certainly been interesting.
Thank you, Manav. Thank you so much. My apologies, vagaries of technology. I was disconnected in between, but thank you so much for holding the fort with those insights. And I think we'll now go back to Gayatri for more on data protection. Gayatri, everyone's been waiting for a condensed bill on this, and where each jurisdiction across the world is coming up with their own set of rules on data protection, with extraterritorial jurisdiction with some of these acts. What are your thoughts on where India is headed, and how soon can we also look at some sort of method to this data protection?
So we do have some level of protection. It's nowhere close to what is desirable. Though its compliance requirements are minimal when it comes to, so a lot of companies would be very happy with what we have right now. But there is an overall acknowledgement that we need to get much better on this area. So I think I'd start with that. I think your question on how soon, if you were to look at the JPC recommendations, it would strike you that the JPC has been very, clinical in saying that it all has to be implemented within 24 months of, enactment. But I think where the part that's equally significant is that the recommendations that the JPC has made, that it will require rewriting of the bill. So I don't see how a bill is going to be passed anytime soon. It's going to take some time to rewrite if all the recommendations are taken on board, right? So that's a bit of I would point to that, and I'd say that it's early days to say that we're going to have a law anytime soon, given the recommendations. In terms of the recommendations itself, I think they're not surprising in terms of what the sentiment is from the government's perspective or the executive's perspective. A lot of the executive wish lists have been pushed through the JPC recommendations. I'd say that, but it's certainly surprising that they're all getting pushed through under a bill which is meant for data protection. I think that's startling. In that sense, I think this is one of the first times I've seen that such wide-ranging recommendations have been made with respect to a law which was supposed to be very specific to a particular area, right? So that's, I think, the other one that's a little unusual. But in terms of the JPC's recommendation itself, not surprising that the government exemptions have been retained, maybe even broadened to an extent when you take away the limitation of the lawful purpose for an exemption. So that is not surprising. I think it's been the trend. It'll get challenged, I expect, if it were to go through in a law, but that's not surprising. I think that the second aspect of it was also that the government supervision, right, with data transfer contracts. Now the Data Protection Authority, according to the JPC's recommendation, is to take the government's view, the central government's view, that we're adding one more layer to it and increasing the government's protection. But I think the area, and the third area is, of course, that non-personal data is going to be dealt with. So it's not just going to be personal data and its protection. It's going to get non-personal data. So it's going to get much broader. The scope of the statute. You're going to basically regulate all of data, right? Which was an area which was left. Is there a need for that regulation? Is a question. So that's a third area, I think, that is a bit controversial. I'd say that's controversial, right? But the one that's really there are two aspects where the JPC recommends regulating hardware devices to see if they comply with data security. Now that is a shift. If that were to happen, it would be a significant move. The JPC recommends that you should have hardware reviewed and regulated and guidelines to see compliance with data security. That's a shift. In fact, even an individual, according to the JPC, even an individual should have have the ability to check their device to see if the device is maintaining that data security. So that I think would be a significant move. The other areas, of course, social media platforms. I think that's a place where the government's really made its intention known. I'd say the JPC's made the intention of the government known, if I put it that way, right? So this very, very, there's a clear, kind of policy intent to make social media platforms liable for content, which is a matter of concern. Publisher liability for what's ultimately a platform where people meet each other and talk to each other we need to think about it. I really think thought needs to be given to it, and I expect it will end up in courts if it was implemented. The second area, I think, is to verify all user accounts. Now that may make it difficult for social media platforms to operate, considering the way that they are structured. Right? So to verify every account it may be difficult to comply with. That's the second part. I think the third part is to disclose the fairness of algorithms. That is a debatable. There may be justification, not from a data protection perspective, but there may be justification from an overall regulation of social media platforms that, the algorithms that are used, whether they're used fairly, the profiling, etc. Those issues can be looked at by a regulator. Whether that should be a competition law issue or there should be a specific regulator for that is a different matter. But I think to that extent, there may be some justification that AIs are not used, in a way which would impact the user from a consumer, perspective. There could be justification, for that. So that's an area that I think that could be, broadly justified. But if you look at all of these changes that are being referred to, that are being recommended by the JPC, the one thing that stands out is it's going to take a long time to rewrite that bill. I think that was like my first impression when I read it. And of course, it'll end up in court. There's no way it's not going to happen.
All right, thanks for those insights. Just to take your overview on how would you rate the success of the data protection bill compared to other jurisdictions? Like we know GDPR has been recognized as one of the most robust regulations. How would you rate India's regulation on that?
So we're yet to see what shape it will take, Ashima. Right now, it's just a proposed law. But I think the intention, particularly after the Shri Krishna committee, the intention was to give robust protection comparable to GDPR. It was it's consent-based, with a lawful purpose, just one subset of it, but certainly make it as robust as the GDPR. What you've seen in the bill that was actually before the, tabled before, Parliament, the houses, tried to whittle away by giving the government a lot of exemptions. I think that was one of the areas where there was a lot of whittling away. And then there were these stray provisions, right? Such as, I'm not going into localization, but there may be justification for localization in certain instances. But, whittling it away by saying that we can direct you to hand over non-personal data, etc. You're losing focus from what the law is actually about, right? So those are places, I think. And now we're I think we're slipping further away from the focus of the legislation with all of these issues that I just discussed. Right, you increase the exemptions for the government. You increase supervision, virtually surveillance of the government in effect, right? And then you're the third level that you start regulating industries through this, whether it's a hardware industry or the social media platforms. It's somehow no longer data protection. Well, it's a lot more like let's get all digital assets under this law, and that I think it doesn't look like we'll accomplish much soon, in my view.
Thank you, Gayatri. Thank you so much for your views in that. Quite enlightening. Coming to you, Bharat, on who is a police officer, I think that's something a lot of our audiences would love to know. Over to you.
Thanks, Ashima, for that. I mean, the question, if you're asking that question today in 2021 on who is a police officer really in terms of law or for the purposes of law, that by itself is a serious or should be a serious cause for concern, and shows, how drafting of different laws should be better, how we should move towards a more, a certain framework of what laws are. I'll just give you briefly the context and very, very important issue. I mean, in ordinary parlance, anyone who wears a uniform investigates cases as a police officer, right? But law is hardly that simple. Traditionally, the reason we ask the question, who is a police officer, is important for a few reasons. Under the law, any statement given to a police officer during an investigation is inadmissible. Any confession given to a police officer by a suspect is inadmissible. And why do we do that? Because of the general policy distrust or the distrust of the law in the police officer's ability to investigate independently. Because right from the very start, we've recognized that an investigating officer, more often than not, would be inclined to rub chili in the eyes of a poor accused rather than investigating the matter forensically and looking for independent evidences, which would always be more difficult than getting the accused to write a confession. And you get a confession written, you can have a successful prosecution. That was the mischief sought to be remedied by the law. That's the reason in 1872 the architects of the Indian Evidence Act, Sir Fitzjames Stephen, they said that any confession to a police officer is inadmissible, any statement to a police officer is inadmissible. Now the difficulty is that over the last few years, criminal law has become more and more specialized. There are special laws dealing with various aspects of criminal law. You have the Prevention of Money Laundering Act. You have the Companies Act, which deals with fraud. You have NDPS for narcotics investigations. You have laws such as the Maharashtra Control of Organized Crimes Act for big gangs and those investigations. What these laws seek to do is they give investigative powers to people who are traditionally not police officers. They're not part of the police services of the state. They are special officers who've been given powers of investigation akin to that of a police officer, but they are not police officers themselves. So what is the inevitable consequence of this? They have all the powers of a police officer. They can go make an arrest. They can go do a raid. They can seize property. They can take police custody, remand, interrogation, and so on. But they don't have the same scrutiny that's otherwise applicable on a police officer. So you have the best of both worlds. You can investigate like a police officer, but you're not subjected to the same safeguards or checks and balances. You can record a statement of an accused as an ED officer, and that would be admissible in a court of law. And we understand how those statements are recorded more often than not. It's your pen, your paper. You can sort of get anything written more often than not. So this has been the position, and we've been arguing that this not considering all these special investigative agencies as quote unquote police officers is problematic from the Constitution standpoint, and accused has a right to silence, and they cannot be trusted to record the statements correctly. Please take the person to a magistrate, get the statement recorded there. Don't make it admissible because it's always bound to be self-serving. That's the position. So for the longest time, these officers were not considered police officers. Now, and this is where I come to the judgment, Tufan Singh's judgment, the Supreme Court says that officers under the NDPS Act, investigating NDPS offenses, even if they're not police officers per se, are going to be treated as police officers. So any statement given to them is not going to be admissible, is not going to be worth the paper it is on. It's very, very important. Now the question is that this ratio or this proposition can be extended to various other special laws, where an SFIO officer investigating a fraud case under the Companies Act can be taken to be a police officer, and the statements would be of no evidentiary worth. Same for ED, same for a couple of other special agencies. And I personally think it's a very, very healthy development because one, these laws, and I'm not just speaking as a defense counsel today. I'm also speaking as somebody who's had the occasion of deciding some of these cases or extending remands in some of these cases and having that ringside view of how investigations take place and how one-sided they are. I personally think that there is These laws are very, very draconian, very serious punishments. Bail is usually not a right. They are very widely worded. So anything and anything can amount to a fraud under the Companies Act. Money laundering is so vaguely defined that almost any activity may be money laundering. Given how vague these laws are and how all encompassing they are, it's important to restrict the powers of the state. Now, the state obviously has a monopoly on violence, but that has to be checked by the courts. And this decision would go a long way in making that possible and making criminal justice system all in all more humane and more transparent and more objective, because, and I'll end with this, the only thing that distinguishes a criminal system from a criminal justice system is justice, right? And I think that decisions such as these, which are personal liberty oriented, go on to retain the justice in the criminal justice system. So yeah.
Thank you so much, Bharat. And of course, I think NDPS has been in the news with the Aryan Khan case, and every citizen has taken such interest in the matter and has come out saying that how draconian they all feel it is. So we hope things are settled in times to come. We look forward to a little lesser strictness there. But anyway, going around the floor again and coming to Parth for the international trade discussion. We unfortunately are closing to 1 p.m. But I think we can take 5 to 10 minutes beyond 1 to have the final round. Parth, coming to you and requesting our panelists to spare 10 minutes above 1 for the closure of the discussion.
Sure. Thanks, Ashima, again. So before I talk about the carbon border tax, I think it's very important to set out the context in which what is happening, right? So if you look at the trends which in last couple of years, even before pandemic, there was a sense of, you would see trade policies across globe where inward looking, and WTO has become almost dysfunctional with the United States blocking appointment of appellate bodies, so rule-based system was not enforced. More and more countries started taking positions which were beneficial for their own domestic industry. Whether they are economically beneficial or not in long term, that's a separate issue. That's a question of economics, but at least from a political economy perspective and political constituency, people were trying to protect their own domestic industries. And that was largely a fallout of, again, United States and China trade war. And this got accelerated with the pandemic. In the pandemic, everyone suddenly realized that how the supply chain issues has been completely, ruptured, and over dependency on few countries, including China, that is ultimately harming people. I mean, semiconductor is one great example. Today, you are seeing that, India has now come out with a package. United States, if you go back like 3 months back, came out with a $55 billion package for semiconductor. And there are other sectors. The semiconductor is just an example. So the entire, government or state policy towards, putting your house in order in terms of being self-sufficient is something which has been largely accelerated further by pandemic as well. Now, it is in this context, some people view what is happening in European Union, where they have, promulgated something what they call is carbon border adjustment mechanism, in short CBAM. It's sort of a border tax. Now, of course, the way, Ms. Ursula von der Leyen, who is the president of the European Union, has projected it, it is about, fit at 52 and, how European Union's history and how they are committed towards, reducing carbon emissions and climate change, addressing the issues of climate change. And it has been projected from that angle. But here are the issues, and I'll briefly tell you what are the practical implications of it on Indian exporters and therefore Indian economy, export economy, and what are the legal implications. So at least the narrative which has been created is to create, that this is meant for addressing climate change issues. But let's understand that the issues of climate change are subject of wider multilateral agreements, which is UN framework, and we recently had COP26 in Glasgow, Scotland. So what is happening here is that a country or a group of countries, European and large trading bloc, is using trade as a lever to externalize in one way carbon emission obligations, which I don't own. What the carbon border tax will do, essentially, and it's a very complicated set of mechanism. The rules have not yet come. Some of the rules will be formulated. It's only a proposal. The rules are yet to be formulated, and there is some transition period. But effectively, the idea which has been floated is that if European producers of certain goods are complying with higher norms of greenhouse gas emissions in this, their cost of production is costly. And if certain other exporting countries are still on the traditional sources of energy, conventional sources of energy, their cost of production is cheaper. So in order to create a balance, a competitive balance, in order to create a level playing field at the border, I will impose certain amount of duty over and above the normal customs duty which I put. And that's why they call it a carbon border tax. Now, how will they calculate how much amount of duty they will put? All of that is very, very complex issue. They'll have to come out with, they'll have to assign values that how much embedded carbon emission is there. And this is even more complicated because, typically manufacturing doesn't happen that you create everything here. You might have taken some product from some country, it's assembly more so to say, it's a value chain, and you don't know from where. So all that complications given, we are not getting into that. The idea is that I'm trying to create a level playing field for my domestic producer, and that's why I'm putting this carbon tax. Now, of course, European President has said that this is WTO consistent. Now, whether it is WTO consistent or not, it's hugely questionable because this will be hugely challenged. I mean, India has already taken a position along with some other countries, basic group of countries, that they are concerned with this. This is not in line with WTO, and we don't have the full print. But be that as it may, the issue is, if this law comes in, is it going to impact India? Answer is yes. Europe is India's third largest exporting partner. The law will come into full effect by 1st Jan 2026, but between that, there is a transition period. And this transition period, if Indian exporters are not on board, if they don't do the necessary steps, because you will not be able to import unless you are an authorized importer of a product, which product has been listed in CBAM group. And those products today include metals, which is aluminum and iron, which is one of the key products, the key sectors which India exports to European Union. You won't be able to import. Now, given whatever position India has, if the Indian government and the exporters do not come on board, they will lose competition because export markets are very, very competitive. And once you have lost your customer base in a particular country, my own experience as a trade lawyer, it's very difficult to get back your customer base. And who are your competitors? If you talk about metals, your competitor is China, United States, and there are some countries in Southeast Asia, including Japan, in the Far East. It's very difficult to get back to your customer base. So it's very important for India, despite its opposition, to come on board, discuss the issue, and at least prepare. Whatever will happen in 2000, people will see. If you don't have a functional appellate body, I don't know whether there will be a resolution to this issue, but Indian exporters have to do that. But these are the practical implications. If they don't do, they will lose the market, and therefore the government has to act. In terms of legal implications, one issue, of course, is WTO consistency, but then it opens a larger Pandora's box here, which is, if you effectively look at, the European Commission has posited it as a competition issue, right? And a competition issue, if posited in this way, which is between foreign imports from foreign countries and domestic products, it has a slippery slope in the sense that what other countries are doing in terms of greenhouse gas emissions, they are currently following what they are actually expected to do under the larger UN framework on these issues, the larger multilateral agreement. Now you are coercing someone to do something because you think that the other countries are not up to the mark as you think they should be. Now, if that is the standard on which I was supposed to act, then let's look at it. If you look at the cost of access to capital in certain other countries, including Europe, it's far lesser than India, right? If an exporter from Europe is exporting goods to India, I may have an argument that the access to capital in that country is quite cheap if you compare the interest rates. And therefore, this is a subsidy. And I will now impose a countervailing duty or anti-subsidy duty at the border. But that's not the way it works. It will be violative. What is a subsidy has to be understood the way subsidy has been defined in the relevant agreement. There is agreement on WTO. I don't want to make it complicated, but the slippery slope and the idea what European Union is doing is actually, I can utilize it to do everywhere, wherever. So if I think that in some particular country, labor is very cheap, I'll start imposing duties at the border because I'll say that labor in my country is very costly. and therefore I'm going to impose duties on that. But that's not how the subsidy regime works. But what EU has done will essentially lead to this, and they won't have a reply to this. This is huge. This is going to again be hugely litigated at international courts and also between countries. But for the time being, in the short term, Indian exporters have to comply with it. Otherwise, they are going to face the brunt. I'll stop here.
Thank you, Parth. And a big thank you to all of you for sharing these insights and these nuanced sides of your practices that we've had a chance to look at. Thank you so much. I'd quickly like to take your views on what's something that you're looking forward to in 2022. Very quickly, just one thing, one law, judgment, policy, anything that you're really keeping your eyes peeled for. Manav, coming to you.
So let me not be the person who takes this over the scheduled time. So I'm going to make this very quick, but I'm at the same time not going to restrict myself to one. While there has been a lot of movement on ease of doing business, certainly, I think there's still a need for further easing up of some bottlenecks, especially for foreign players. We've seen challenges in speed in foreign players opening demat accounts, getting KYCs done, getting their PAN done, therefore impacting either an investment or exit. I think one of the other things that we'd like to see is given the move to have LLPs as a viable business model, as opposed to a company, some amount of regulatory clarity on purchase and sales of LLPs, interest, including cross-border transactions, in a same manner as it would have been had it been a company. If we allow for alternative business models to emerge, we need to also allow for clarity to be there, for them to be realistic alternative models, both in terms of entry, in terms of governance, in terms of how they operate, in terms of licensing, in terms of regulation, and in terms of exit. So while in India, companies have been well established and there's a fair amount of precedent, there isn't so much in terms of LLPs, and I for one would like to see something around that. And I believe that we may see some amount of movement on some labor law clarity, especially on work from home, hybrid model, some of that. While there has been a fair amount of movement on that, it's largely been reactive, where it's been to address the particular situation that crops up at that point in time. But to invite suggestions from various stakeholders and to come out with a clear forward-looking policy on some of these. I'm hopeful that some of that will happen, and if it happens, we'll sit here at the same time next year, and say, we either foresee what came about, or we were happy that it came about, or we said it didn't happen at all. But that's my 2 cents, Ashima, and I may have spoken a little fast, but I'm cognizant of the time. So
thank you so much, Manav. Great picks there. Thank you so much for shining light on that. Gayatri, coming to you for what you are looking forward to in 2022.
I'll have to go back to the more traditional IP, right? So I'm hoping that the 2012 amendments work themselves out, particularly when it comes to the authors' rights versus copyright owners' rights. I think that it's about time, considering the various challenges that are faced because of the provisions and the ambiguous nature. I think that's very important. I think the other one that I'm really looking forward to is that there's this issue in patent cases, pharmaceutical compounds, where you have patenting for the genus and the species, whether that's a viable patenting strategy for India. It can be a very valuable patenting strategy, whether it's a viable patenting strategy. I expect that those 2 areas are going to get resolved this year. And I'd look forward to it. I think that would be a great development.
Thank you, Gayatri. Thank you so much. And Parth, coming to you for your choices.
Quickly, so again, there are many laws where I would like some reform, but I will not get into that given the time frame. But I have a larger comment on the policy making, and I think in 2022, if government can be a little more coherent and little more clear about its policies, and that is cutting across. And I come from trade and competition background, so just to give you an example, like suddenly the government is in huge rush of finalizing FTAs. Today, if you open newspapers, the other day I was in a discussion which we're doing with the UAE FTA. Now you have Taiwan FTA, Australia FTA, Canada FTA, and European Union has also gotten up. At the same time, government also has completely amended rules of origin, in which effectively the government is reneging on all the bargain under the FTAs, which preferential tariff, which the treatment which they have given to the other countries, that has been completely reneged on. So it's not clear what the government wants, right? At one hand, you want to rush with these FTAs. At the other hand, you complain about FTAs because you think that they are taking away opportunities from you and your, domestic companies. So little bit of clarity and coherence with respect to policy making, which is scientific, data driven, and not just decided in a room. That's what would be helpful in my view. Thank you.
Thank you, Parth. Thank you so much. And Bharat, coming to you, what is it that you'd like to see in 2022 taking shape?
I think I was very keenly hearing my learned friends here. Essentially, all of them have argued for clearer laws, lesser interpretational issues that go to court. So I clearly see that their 2020, resolution is effectively putting me out of business. Where we take these disputes to court and fight over the semantics and reading between the lines and so on. But that's on the lighter side. I personally look forward on two counts. One is we've been criminalizing business decisions. We have a lot of criminal laws which are too wide, and they criminalize bona fide business decisions and cast the net too wide. Not every breach of contract, not every shareholder dispute, not every investment decision gone south is a crime. But effectively, that's what it comes out to be in India, where we sort of over prosecute. We don't grant bails as often as we should. There are higher thresholds for bail in most of these special laws, and many of these cases, and we have the opportunity of being in some of them. I think the Supreme Court should, and we expect it to, strike down some of these laws, or at least read them down, making the criminal justice system, as I said, more humane. And I think the biggest beast that needs to be vanquished, not just in the next year, and it may be a 10-year plan or so, is to counter pendency. We need to really get those numbers under control. That's the only way to decide the disputes that we have qualitatively, and make the system more just. And until we have those numbers under control, I don't think we'll be able to do it. And cases and files before we sleep, and maybe and hopefully we are able to get that under control. Thank you.
Thank you, Bharat. Thank you so much. And thank you so much to all our panelists today for joining us on a weekday and shedding light on so many important aspects and giving us a recap of the year and your expectations of 2022. Thank you so much once again. And thank you to our audiences who spared time to join us. We'll see you next week again. So thank you so much.